All right, I want to be respectful of everybody's time, so my clock says it's noon. Thank you all so much for joining. I hope that you and your families are staying safe and healthy and distanced. So thank you for joining me this afternoon. We're going to talk about what makes a special needs trust so special. I'm Emily Kyle, for those of you who don't know, and we have a practice here in Scottsdale. And our firm is Kyle and Kupaszewski Law Firm, and so thank you so much for joining us. I do want to remind you that this is general information about special needs trusts, and if you need specific information about your specific situation, obviously I would encourage you to seek an attorney who understands special needs trusts and not just rely on a presentation. So your individual circumstances will be very individual and should be treated as such with that respect. So we'll go ahead. We're going to take questions at the end, but there is a control on your screen that's a chat box, and you can type your questions in there. My assistant Sarah is watching the chat box carefully, and so if you have any issues with connectivity or other problems, by all means just let her know and she'll do what she can to be helpful. And as I said, she'll be reading those questions at the end of the program today. The program is also being recorded, so if you know somebody who was unable to attend, you can certainly direct them to our website, or if you want to rewatch any part of it, and it will be available soon afterwards right up on the website for your use. So thank you. So the main reason why we do a special needs trust is because certain public benefits require that the applicant or the recipient of those benefits has assets of less than $2,000. There are probably some other requirements they have to meet, but the special needs trust is created just related to the resource limit. So for example, SSI, supplemental security income, any income that you earn could potentially reduce that SSI payment, and special needs trusts have very little to do with that piece. You also obviously have to qualify medically for both the SSI benefit as well as Medicaid, what we know in our state as all-tax benefits. For some of your loved ones, they may have qualified for benefits through the Department of Developmental Disability, called DDD, but not get all-tax benefits, and so they may be receiving very limited services. But all-tax is going to have a resource limit of $2,000 total resources at the end of any month for the person who's in need of those benefits. So the point, again, of the special needs trust is to have a place to put the money that would be over that resource limit and still allow the beneficiary to get the benefit of the money that's in the trust. Because as we all know, the maximum SSI payment is $783 a month, and all-tax doesn't cover everything. It doesn't provide services that cover every single thing that your loved one would need, and so having money in that trust would increase assets that are available to take care of that person. So what is the special needs trust? Again, the purpose is to make sure that the money that's over the $2,000 limit would be in the trust so that they can benefit from the services. In a properly drafted special needs trust, the resources are not counted, as we say, meaning that they don't bump up against that $2,000 limit, kind of regardless of what that asset is. So it could be a house, it could be a bank account, it could be an investment account. Whatever that asset is that's titled in that properly drafted trust should not count towards that $2,000 limit. And as I said, the purpose of the trust is to have money so we can enhance the life and the care and the needs of the beneficiary who's receiving some assistance from state or federal government. Special needs trust is a word that we use. They're also sometimes called supplemental needs trusts, supplemental care trusts, special treatment trusts. So they could have all kinds of different names. It's really, what does the trust say? What are the terms of the trust? That's what tells us whether or not, in fact, it's it is a special needs trust and therefore will qualify to shield those other resources. So how does a special needs trust work? And I use the shorthand of SNT. Sometimes you'll hear some speaker call it a SNT. So that's what it stands for: Special Needs Trust, Supplemental Needs Trust, Special Treatment Trust. So these are sort of the players in the trust. We have the donor or the trust maker or the trustor or the grantor, lots of different names. And so that's where the money comes from. What's the source of the funds coming into the trust? Then we have the beneficiary. That's the person who's going to benefit from the funds in the trust. And of course, we have the trustee. The trustee is the one who's in charge of the trust. They're the ones who are going to make the decisions about what kinds of distributions, when are the distributions made, how are the distributions made. So very much like maybe your revocable trust that you have as part of your normal estate plan, or you know somebody who has a trust. Same basic principles of how the trust works or who the players are in that trust. So the trustee must have sole discretion as to the distributions. If you have a trust that says the beneficiary will get 10% per year for the rest of their life, then that piece is not at the discretion of the trustee, because you've said in your trust document the trustee must make that distribution of that certain percentage. And so in a special needs trust, we want the trustee to have total control. In some months, there might be lots of large distributions. In some months, there might be less distributions. Maybe there's a distribution in a month to purchase an asset or pay for clothing or buy furniture. And then in other months, those distributions are going to be different. So the distributions are going to be different day to day, month to month, week to week, based on whatever the needs of the beneficiary are. And I say here that the beneficiary can't demand the funds. We all know we might have a beneficiary who is saying to their trustee, you must give me money. I need money. I have to have the money. They can make the demand. The issue is that the trustee does not have to comply with the demand. There's no requirement that the trustee follow through on what the request is of the beneficiary. That's super important, and also that the beneficiary does not have direct access to the trust money. So if you give the beneficiary an unlimited debit card directly to your trust account, then the beneficiary has 100% access to the funds in the account, and that could make the money not get the special treatment, that is, that those resources are not exempt for determining eligibility for that beneficiary. Now, it is true that you can give your beneficiary a prepaid debit card called a TrueLink card. That's a card that you would load a certain amount of money on, but that you would block a cash distribution. And you might block other distributions so they can only use it for limited spending. But if you have a card where they have access to the cash, then Social Security and Alltex will treat it as if they used all of the money. That is, they had access to it. Therefore, if that puts them over the $2,000 limit, then they may not qualify for benefits in that month. The beneficiary, as I've said, does not have control over the funds that are in the trust. Only the trustee has control over the assets that are in that trust. So we don't want to lose that control by the trustee. We want the trustee to maintain that control. The source of the money is really, really important because we have different kinds of special needs trusts. Just to make things more complicated for you, as if you haven't had to learn an entire alphabet of information that you may never have heard of before, now you have to find out there's actually more than one kind of special needs trust. So oftentimes the money might come from a personal injury settlement. Maybe somebody was a child or an adult and they had a car accident, or there's a medical malpractice claim. And so now we have money that belongs to the beneficiary, that belongs to that injured or disabled person. And so that has to go into a certain kind of a special needs trust. At other times, we have money that we may have inherited, and that inheritance says it goes directly into a special needs trust. So that would be money from a different source. So we have to be really conscientious and understand what's the source of the money. So what we refer to as a first-party special needs trust, sometimes called a D4A trust because that's where it is in the federal statute, that's the kind of trust we would create when the special needs beneficiary owns the money. And you may be thinking, you know, my 4-year-old who had a medical malpractice claim and received $1 million, they don't really own the money, they're a child. Well, in legal terms, they do own the money. It just might be that somebody else has to manage those funds for them. But if it's the beneficiary's money, which often comes from a settlement or a personal injury award or something along those lines, or maybe we had an estate plan and grandma or somebody else left money outright to a beneficiary who's receiving SSI or all tax benefits. That also would have to go into a special needs trust in order to retain benefits. There are ABLE accounts, and I don't want to throw more information at you, and I'll be doing another program talking just about ABLE accounts, but putting that aside, if they received money and it needed to go into a trust, it would have to go into that first party special needs trust. And sometimes we have retroactive pay or refunds of some kind that come to the beneficiary that would impact their benefits, and that money also would go into a first-party special needs trust. And I want to tell you, it's not a choice. So if it's the beneficiary's money, we must provide it to the first-party special needs trust, which I'm going to talk about, and you're going to say, but I don't really love those terms. But we don't really have a choice. It's a trade-off of, in order for somebody to retain benefits and get those benefits at no cost, it's also true that we have to follow the rules so that they meet the requirements. So we have a subset of these first-party trusts, and we're going to talk about third-party or estate planning trusts in just a moment. But pooled trusts, whether first-party or third-party, means that they're run by a nonprofit organization, and they have a professional trustee to manage the money. And just as it suggests, that trustee is managing money for a lot of people who are all similarly situated. That is, lots of people who are receiving these kinds of government benefits and need to keep their assets below $2,000. So you get the advantage of having a trustee, typically at a much lower cost, a professional trustee, because they're managing a bunch of money for a bunch of similarly situated beneficiaries. Understand, though, that your loved one's money will be accounted for separately. Your loved one doesn't get to use somebody else's money if they run out of their own, and nobody gets to use their money either while your loved one's still alive. And we're going to have a presentation with Plan of Arizona, Liz Kozloff, who's the executive director, on October 7th. She's going to do a presentation on how pooled trusts work. So if that's something you're interested in, just keep your eyes open for the invitation, and we'll have her chat about how pooled trusts work in much more detail. So the first party special needs trust, again, that's money that the beneficiary is receiving directly. That money is required to go back to the state of Arizona's All-Tax program when the beneficiary dies. So I've done lots of programs on special needs trusts, and almost always when I have a live audience, somebody will say, do we have to pay the money back now? My child or my loved one's been on benefits for a long time. The answer is that payback doesn't come to fruition until the beneficiary has passed away. And at that point, the Medicaid agency, through its collection agency, will determine how much money needs to be paid back. They would never get more than what's in the trust. So you are not personally responsible for paying all tax back. The trustee would have to pay from the trust assets the money that's accrued on the debt. So believe it or not, Altex is keeping track of how much they're spending on behalf of your loved one with a formula. And so when your loved one passes away, they'll ask, are there any assets? Are there any assets in a trust? And so that at the time of death or termination of the trust, then we have to figure out how to pay the state back for the services that have been provided. The same is true of a pooled trust, but just slightly different. And again, Liz will talk about that when we have our program with her. So let's talk about third-party special needs trusts, which are really part of an estate plan. So I have a niece, many of you know, her name is Marissa, and she's 26 years old, and she has Down syndrome. So as part of the estate plan in my family, I created a special needs trust for Marissa. That's a third-party special needs trust. And so it, in my estate plan, because I don't have any children, it says if a share were to go to Marissa, then that share would go into the Marissa Special Needs Trust that was created. And that kind of trust doesn't have that payback to the state requirement. So that trust can say if Marissa's deceased, her share would go equally to her then living siblings. It doesn't go back to the state of Arizona or any other state Medicaid agency that provided services, because the source of the money was from my estate or from Marissa's grandmother's estate or from Marissa's parents' estate. So that was never Marissa's money to start with. And so the person who drafts the trust has the right to make sure that those funds can go to somebody else. They don't have to go back to the state of Arizona or any other state that provided Medicaid benefits. And in fact, we wouldn't want to see that language in this kind of trust. This one you have complete control over how it's set up for the most part, who the beneficiaries are going to be. There are clearly some limitations. Again, the trust has to be discretionary only on the trustee, meaning the distributions are at the discretion of the trustee. So distributions, right? That's the money that's going to go out, and we need to make sure that we're following the rules of the trust. In our first party special needs trust, Arizona actually has a statute, and I think we're the only state who has this, that says exactly what the trustee can use the money for. And as many of you may know, we have to provide a budget to Altex in advance as to how the funds are going to be spent each month in various categories. So we have to project how we think those funds are going to be spent, provide that budget, give Altex notice. They get 45 days to tell us if they don't like the budget or have questions. Every year you have to submit a new budget. If something changes, you have to submit an amended budget. So lots of rules around these first party special needs trusts. Also, we draft a special needs trust for one special needs beneficiary. Each beneficiary would have its own trust if you're going to have a first party special needs trust. For our third party special needs trust, again, part of your estate plan, and it can be a standalone document. So the Marissa Special Needs Trust, that's all by itself. It could be provisions in your trust that says, when I die, these are the provisions for Marissa. I could say in my will and set up what those provisions are for her with all of the special needs language. You could have a standalone special needs trust, the Marissa Special Needs Trust, and it could be for a bunch of disabled beneficiaries. So if I had relatives or friends or loved ones, and there was more than one, and I wanted them to share in that pot, you can do that in a third-party special needs trust, but not in the first-party special needs trust. So again, much more flexibility in these kinds of trusts, and I would encourage you as part of your own estate plan to make sure you either have provisions in your trust, a separate trust, or provisions in your will for your loved one who may be receiving or will be entitled to SSI or Altex benefits, so that we can make sure that it doesn't have to go into a first-party special needs trust, and that we can use the money in a more flexible way for the benefit of the beneficiary. So You do have to tell all tax and Social Security when there's a trust for the benefit of somebody who's receiving those benefits and there's money titled to the trust. So when we drafted the trust for Marissa, there's no money in it, right? There won't be any money in it until a relative passes away who's named that trust as the beneficiary. So I don't have to report it to any agencies because it doesn't own anything. It could be that I terminate it before it ever has any money in it. But as soon as there are funds in either a first-party special needs trust or a third-party special needs trust, that trust document and all of the information, all of the assets associated with it must be provided to the agencies that are providing services. For the first-party special needs trust, we have lots of requirements. As I said, we have to provide that budget to Alltex. We have to keep Alltex apprised of if the beneficiary moves or where the trustee is. Change in marital status might change what benefits that person is entitled to. And definitely if the trust terminates, if that first party trust terminates, we need to let Alltex know about it so they can determine what, if any, money needs to be paid back to the state of Arizona or any other Alltex or Medicaid programs that that person has benefited from. So Social Security has a very straightforward step-by-step process that they follow to review these first-party special needs trusts. And it's set forth in their regulations. For our first-party special needs trust, please also remember a couple of things that are super important. First of all, a first-party special needs trust can only be established by a competent beneficiary, a parent, a grandparent, a legal guardian, or the court. So oftentimes for these first-party special needs trusts, we actually need court approval. We can't just draft it, get it signed, and get it funded. We would need for somebody to go to court and get permission. So even though the parent can create the trust, the parent doesn't have the ability legally to take money of that disabled beneficiary and transfer it into the trust. So we might need permission from the court in order to make the transfer and in order to pick who the trustee is going to be. If we have a competent disabled beneficiary who's receiving benefits, then they could sign their own trust. They could sign their own, what we call a joinder agreement, to join the pool. So it's important to understand who can create it and how it gets created. Typically in this situation, you already have some court action because maybe there was a probate and money's going to go directly to your disabled beneficiary, and so you're going to be in front of the court anyway on a probate matter, or a wrongful death or a personal injury claim or a medical malpractice claim. Again, you're probably already in front of the court to get approval of what those settlements or payments are going to look like. So you probably already have the ability to be in front of the court for those. The other thing is that no additional money can go into a first-party special needs trust once the beneficiary turns 65 years old. So that's another complicating factor potentially. That is not true of our third-party special needs trusts. So if Marissa is 70 when I die and money goes into the trust for her that I've drafted, that's completely fine, and she will maintain her benefits and she will keep all of the services that she had prior. But for these kinds of trusts, we have an age cutoff, or there is a complication in terms of them potentially losing benefits and then having to wait some period of time before they would be eligible to get back on benefits. For the review by Social Security, and for the most part by Alltex for third-party special needs trust, and again, you do not have to provide this to any agency until there's money in the trust. So again, if Marissa is not going to have money in the trust until I pass away, then nobody would have told the agencies about the trust until I'm already gone, because I might make changes to it. I might decide not to fund the trust ever. I could determine that I don't want her to be a beneficiary anymore. So we don't have to report to the agencies until there's actually money. And my understanding is that in some states, their Medicaid agencies don't ever ask for these kinds of trusts. So if you're talking to friends or relatives in other states, they may say, no, we don't have to do that here. So you may have a loved one who lives in a different state and they're on Medicaid benefits in that other state. That trust might never be disclosed to the agency. But in Arizona, we must disclose that trust to our All-Tex office or our Access office. As I stated earlier, the third-party special needs trust, we need to make sure it's drafted so that the beneficiary does not have direct access to the trust assets and that we don't put any of the beneficiary's money into the trust. We don't put their SSI payment in there. We don't put their employment money into the trust. That inheritance that they got outright from grandma of $5,000 does not go in this trust. We have to segregate and make sure that the only money in this trust is money from somebody other than the beneficiary. Now, having said that, I could contribute money, the child's grandparent could contribute money, the aunt and the uncle could contribute money, the parents could contribute money, but not the beneficiary and not you on behalf of the beneficiary. So if they got their own money, they won the lottery, we can't put that lottery winnings into this third-party special needs trust. And then the last thing is that the beneficiary can't terminate the trust and they can't act as the trustee. So you would always have somebody else be the trustee, and you would always make sure that there are provisions in there that are clear that the beneficiary can't just say, I want all my money now and go ahead and terminate my trust, because that's not going to work. So as I said at the beginning, we have to have a trustee. That's the one who manages the money. And this is very similar to any other trust that you may already know about. They're going to manage the funds. They're going to make the determination about the distributions. And I've said they're going to report to Social Security and or Access, but the trust may not make that a requirement of the trustee. For a competent beneficiary who's their own representative payee, for example, maybe it's going to be the beneficiary's responsibility. In fact, the rules say that it is the beneficiary's responsibility unless they have a representative payee through Social Security or an authorized representative through the Access program. We typically tell our trustees, you know what, this is a big deal and we want to make sure that it's really done correctly and that we have all the paperwork to show that we did the reporting. So it's nice for the trustee to do that and be able to have those records in case a question were to come up later, like the agency said, we never received it or you didn't report it. We can say, yes, we did. We reported it here. Here's your green card showing that it went by certified mail and was accepted by the agency. Typically, the trustee is also going to be responsible for filing the tax returns on behalf of the trust. So be really careful about who you name as the trustee, right? That's a lot of responsibility to put on somebody. So we want to make sure we've got the right person in that role as trustee, that they will understand the complexities of acting as a trustee of a special needs trust. And I would say absolutely that's true whether it's a first party or it's a third party trust. The only limitation is that the beneficiary would not be the trustee because then they would have access to the money. You can also have provisions for somebody to remove and replace the trustee or appoint a successor. You could say that the trustee has that authority. You could have what we call a trust advisor or a trust protector who would have the authority to name successors. I've found with most families, as in my own family, we have very few people that we trust. And so trying to come up with who's the trustee and then also a trust protector can be kind of overwhelming. But you want to make sure that we have provisions in the trust to be able to appoint, remove, and replace trustees, and that all of that makes sense. I strongly encourage you to name a corporate entity or a licensed fiduciary as a trustee because we need to make sure the trustee is going to outlive the beneficiary. So if you name your sister, assuming that you're the parent of that beneficiary, probably your sister is pretty close to you in age and probably your child is not. And so we need to make sure that we have somebody or an entity that's going to be around for a while. Another thing you could do is say that the trustee has the right to appoint a licensed fiduciary, so that in the event that they don't want to act or they're getting older themselves, that they have the ability to put in a trustee who can stay there for the long haul. So really think seriously about who that trustee should be. There is some impact on SSI when you make distributions from a special needs trust. So the government believes that the SSI payment of a whopping $783 a month should be enough to meet all of the food and shelter expenses for the beneficiary. And I think we all know that that's probably not really perfect. But if the trust is paying for food and shelter, there's going to be some deduction to the SSI. If the individual is using their SSI to pay all of their food and shelter expenses, then there's no impact on SSI, because that's how the government thinks the SSI payment should be used. If you, as a parent or a loved one, are paying for all of the food and shelter for that beneficiary, there also will be a reduction to the SSI payment. Now, I've seen trusts that say the trustee shall not pay for food and shelter, and I'm not sure exactly why that would be. You wouldn't lose all of the SSI, there would just be a reduction. And as I said, typically $783 is not going to be enough to meet all those requirements. So to then restrict the only pot of money we have from making those payments might not be the perfect outcome either. So we just need to understand that there might be a reduction in the payment because we're paying for the food and shelter expenses from that special needs trust. So I completely understand that this is very complicated, and I've seen that we've gotten a lot of questions or maybe comments in the chat box. I haven't looked at what those are yet. So I get that it's very confusing, first party, third party, pooled trusts. But I want you to understand that these special needs trusts are really, really important and crucial to make sure that a beneficiary who's receiving SSI and or All-Tax benefits can maintain those benefits. We have to make sure that the beneficiary is not going to have direct access to the money. And if it's a competent beneficiary, especially on a first party, so they were injured in some kind of an action, to help that beneficiary understand you don't have complete access to the money. You can help me understand what your needs are and what your wants are, but that the trustee is the one who gets to make the determination about those distributions. There can't be any mandatory distributions, or it will not shield those monies from being counted against that $2,000 limit. So if you've said they get $1,000 a month, that $1,000 a month will count and may or may not impact eligibility. If you've said they get money at age 25, 30, and 35, as they reach those ages, they may become ineligible for benefits. The trustee gets to make all of the decisions about the money, how it's spent, how it's invested, what we use it for, what we buy. And the beneficiary cannot be the trustee. No matter how competent they are, how great they are with money, how financially savvy they might be, it won't count as a special needs trust if they're the trustee, because then they have access to all of the money. One of the really interesting questions I often get is, can a special needs trust own a house? And the answer is yes. If it's a first party special needs trust, the rules actually say that the title has to be in the name of the trust. If you use trust money, like from a settlement or an inheritance, to purchase the house and it's in the trust already, you have to have the title of that house in the name of the trust. If the trust is going to buy a vehicle, we would usually recommend that the vehicle is in the name of the beneficiary, as long as they have a driver's license. And then the trust can hold a lien against the vehicle. So when the vehicle is sold, the money will come back into the trust, and then the trust can use money again to buy another vehicle. We like them to have a lien against the car to protect the trust's interest, meaning the money that it provided for the purchase. but we want the car in the name of the beneficiary so that we can try and cut off any claims in the event that the beneficiary was in an accident. They own the vehicle, not the trust. The trust can have lots of different bank accounts. It can have investment accounts. It can own all kinds of assets, as long as the name of the trust, the Marissa Special Needs Trust, is on those accounts or on those assets. You don't just have to have one checking account, and that's all you can do with the money. The money can be in a money market account, or as I said, it can be in investments. Obviously, the trustee just wants to be very cognizant that this might be all the money that that beneficiary will ever have, that they don't have earning potential in order to increase what the value of their estate will be worth. So you want to make sure that those investments or the purchases are going to meet the needs of the beneficiary for as long as possible. And as I said, as soon as there are any assets or money titled in the name of the trust, it should be reported to Social Security and to Access or Altex, depending on the benefits that the beneficiary is receiving. I will tell you that if you get a letter back from Social Security that they have any issue with the trust, you only have 10 days to file your appeal or request for reconsideration, or they will stop the benefits. So it's very important if the beneficiary is their own representative payee, so they're going to get correspondence. Oftentimes, none of us want to open mail or do something with mail that comes in that's unpleasant, but they can't hide it or procrastinate. We need to know that we can move forward on an appeal in the event that there's a negative ruling by the agencies. Now, having said that, just because they send a letter that says they believe it's a counted resource and there's a problem with it, doesn't mean Social Security wins. It means we have to figure out, are they right or are they wrong? Can we just amend it and fix the problem as the path of least resistance? Or do we need to actually move forward and ask them to reconsider or do an appeal for that purpose? Our Altex office is typically much more kind, and they will send a letter telling us it needs to be amended in these areas, which is why it's very important that there's a provision in both a first-party trust and a third-party trust that allows the trustee to amend the trust to meet the then existing requirements, because I don't know what the requirements might be in 20 years, right? I don't know if Altex is going to change its policies. So we want the ability to stay up with the times. So I'm going to get to the questions or comments. It looked like so far we have about 20 maybe that came in. I do want to let you know that we have some upcoming webinars just like this one. So on August 12th, I'm going to do a presentation focused on kind of more general estate planning, wills and trusts, and sort of the differences. On September 9th, we're going to have a program on ABLE accounts and go into a little bit more detail on SSI. And on October 7th is when we're going to have that program with Plan of Arizona, which is a local pooled special needs trust, to talk about how those work. At some point, we'll have a full calendar up at our website, so you'll be able to see that as well and see what's coming up. But hopefully we'll send you out a notice about every week so you can see what's coming up and see if it's of interest to you. And of course, you can share it with whoever you want. There's nothing proprietary about it. So if somebody else wants to listen and they didn't get the notice, by all means, send it along. And as I said, they will be recorded, so they'll be available on our website. So with that said, Sarah, if there are any questions, I would be happy to get them, and hopefully I can answer them for people.
Okay, perfect. So the first question I have here from one of our attendees: are special needs trusts specifically for someone with special needs?
That's a great question. So a special needs trust is meant for a person who is receiving or would be eligible for benefits that are based on assets. So as I said, if somebody might be have no income and be disabled and they're over the age of 18, they might be eligible for SSI, Supplemental Security Income. Similarly, it might be for a beneficiary who's eligible for DDD or Altex benefits, but for the fact that they have too much money. So they have low income and they are considered to be disabled under the rules of the DDD and Altex program. So if I had a competent beneficiary, so let's say that I had a typical 4-year-old who doesn't have any diagnosis and is meeting all of their milestones, we wouldn't do a special needs trust for that beneficiary. You also might have a beneficiary who is your child and they're 20 and they're terrible with money. And in that case, you wouldn't do a special needs trust, but you could set up a discretionary trust for that beneficiary so that the trustee is controlling all of the money. But you might have a broader standard, that is that the trustee isn't just looking to the government for benefits, but that they can use the money for, education expenses and support of that beneficiary and everything that they might need. And you could reevaluate as the beneficiary ages as to whether they in fact might get more access to the funds. So I hope that answers the question.
Perfect. The next question I have might have been answered partially during your first answer, but what if they are not eligible for ALTEX, only DDD or TSC, Target Support Coordination?
So the issue would be, why are they not eligible for DDD benefits? So if the person is not eligible for DDD because it's a resource question, that is, maybe that beneficiary has $20,000 in the bank, or they got some savings bonds when they were first born, and those savings bonds are more than $2,000, then a special needs trust would make sense. You also might have a beneficiary who doesn't meet the requirements because although they meet the requirements for some programs, they're not disabled enough is not really the right word I want to use, but they don't meet the medical criteria for the ALTEX program. And so they're getting more limited services rather than the full spectrum of services that they might get through ALTEX. For those beneficiaries, again, you might decide to have a discretionary trust. You can also put kind of a default special needs trust in your documents, in your own trust, to say if somebody would become eligible for government assistance, then it would go to that special needs trust. So if the beneficiary's medical condition changed, then you would still have a default so that they wouldn't lose their benefits. I find that to be super helpful because the other thing that happens is, even if all of your children are typical kids, they might later have a child who does have special needs. And so now if your child passes away and it would go to your grandchildren, we still have a place to put the money where they're not going to lose their benefits.
Perfect. Thank you. Our next question is, can the trustee be changed?
So I alluded to that in the presentation, and that is that as long as you have a provision in the trust that explains how you replace trustees, the answer is yes. If you've written the trust to say it's irrevocable and it cannot be changed under any circumstances for any purpose, then we might need to go to court to get the trust amended for that purpose, or look to a state statute and see whether there's something in the statute that would allow us to do that outside of the trust. So you would, most of the time, almost all of the time, want to have a trust that explained who has the authority to remove a trustee, name a new trustee, name a successor. So maybe I'm the trustee for Marissa's trust, but it says that I can name a successor to me before I pass away. So I could say, I'm happy to be the trustee while I'm alive now, but when I pass away, it should be this other person. So that could be a provision of the trust document, both for a first party as well as for the third party trusts.
Thank you. Our next question, why wouldn't one spend the money in the trust prior to starting any state services?
So if the amount that's available for that beneficiary is small and there are things to be purchased, then that's a great plan to avoid the cost and the administration of a special needs trust. So we always recommend, as morbid as it is, to prepay for burial and cremation services. In a first-party special needs trust, when the beneficiary dies, you no longer have access to any money in the trust at all for any purpose. We would need permission from the collection agency for ALTEX in order to access that money, even for a funeral or burial. So paying for that in advance as in an irrevocable plan would be an excellent use of the money, because that doesn't count against the beneficiary either. But if the person is going to receive a larger sum of money, it's nice to have a place to save, because maybe while you're alive, you're providing support to that beneficiary, but when you're gone, there's no other place to get support or money. So if they got $100,000, maybe you would decide, I don't want to spend all of it right away, because I want to have a place where there is extra money when those emergencies arise. So I hope that answered the question.
Thank you. Our next question is, can child support go into a third-party special needs trust?
So child support should go into a first-party special needs trust most of the time, because almost all the time it's the child's money. There might be circumstances in which it can be redirected to a third-party special needs trust. If the beneficiary is on SSI benefits, that would definitely be something you would want to talk to an attorney about, so that you can maximize SSI and still get the child support without making that a dollar-for-dollar reduction or some other reduction to that child support payment. So I would definitely encourage that whoever asked that question, or if somebody else has that question, that you would seek the services of an attorney to look at what the circumstances are, how cooperative the person who's paying the child support will be, and whether you need a court order for that redirection.
Perfect. Our last two questions kind of go hand in hand. They are about homes. So the first part of the question is, can a third-party special needs trust own a home? And if so, if the trust purchases a home, can the beneficiary make payments to the trust as rent for the home?
So a special needs trust can definitely own a home, and the special needs trust can make the payments associated with the property in terms of the utility expenses. The beneficiary could pay rent to the trustee. We'd have to look at the circumstances to see whether that makes sense, because we're basically using the beneficiary's money to pay all of the expenses and to have purchased the property, and then we're having the beneficiary pay the trust back. But if that will assist in not reducing the SSI, that is absolutely a possibility. We also have to determine who has the authority to sign some kind of a rental agreement. And so again, that would be something that you would want to talk to an attorney about to determine what makes the most sense.
Great. I don't have any other questions on my end.
All right. Well, I thank you all so much for attending. I hope that you found it useful, and that you at least got some kernel of information that maybe you didn't know before you started. There will be a short survey that we're going to send out to everybody, along with an offer for a discount on any services to our firm if you've watched our video. So thank you so much. Please do answer the survey. It's super helpful to us. I hope that you and your families remain safe and healthy, and we look forward to the opportunity to work with you in the future. So thank you so much.